Disinformation. False information that is intended to mislead. Deliberate misinformation. This has been a growing problem in the internet age, and I have a particular example I want to draw attention to and describe in detail, which is why I have prepared a glorious PowerPoint presentation. What has been a growing issue is a series of articles claiming that Texas Senate Bill 20 could ban anime, and it's been gaining traction in the legislature. This is, if not a lie, a failure to research on the most basic journalistic principles. I first heard about this issue 1 or 2 months ago when my brother, who is a weeb, asked me about it, and we went through a brief run-through of the assorted laws involved and discussed them and the bill. I thought at that time that this was a very obscure matter that was not about to spread. But I, a non-anime consuming individual, found it pushed into my consumption, meaning it is starting to become widespread. That is why I've decided to make a brief explainer debunking the common claims. The first and most obvious point, Senate Bill 20 does not target anime at all. It introduces a new offense into Penal Code Chapter 43, obscenity. It does not target any genre or country of origin for its content, and it does not target specifically the anime art style. The actual text of the bill introduces it as a crime to knowingly possess, access with intent to view, or promote obscene visual material containing a depiction that appears to be of a child younger than 18 years of age engaging in activities described by Section 43.21A1B, regardless of whether the depiction is an image of an actual child, a cartoon, or animation, or an image created using an artificial intelligence application or other computer software. I know reading that was dry. It is necessary to understand the wider point. There's also a second clause in there against using obscene visual material of children in AI image generating softwares. The immediate response I've gotten from most internet people who react to this is obscene is a vague term, and what led into the common article issue is anime is, I would argue, known for its appeal to the male gaze in many cases. However, obscene has a definition in the penal code, and that is the definition that laws are enforced by. 43.21A1B, the bit cited right there, states patently offensive representations or descriptions of essentially anything that would end up on the hub. It's a list, it's a comprehensive list. But this is only part of the definition of obscene, is specifically the part that in the previous section they cite in described by section. The full definition of obscene, which it does say obscene visual material at the upper part of the bill, also includes material that is in the prudent interest of sex and lacks any serious literary, artistic, political, and scientific value. You need to hit all three of those categories to be obscene. For instance, South Park. It's just a good example to be pulled from. There is a particular sequence that was in the South Park video game that famously got censored in the Australian release of the game, in which an object enters the end of the reproduction system of the main character. Whether or not you consider this particular scene to be despicable, we can all acknowledge that South Park broadly has literary value to the way they format each of their episodes. This applies more broadly to other shows, for example, Game of Thrones. Large amount of literary value does not count as obscene. The reason this matters is because there was a old court case, I forget the name of it, where the Supreme Court defined hub content as not speech legally, but they were very restrictive about the full controls of that. So in this case, while in that particular ruling, such intimate materials could be made illegal, which has drifted since that particular time period, you could not prevent the creation of materials if they did include it as part of a wider speech. This is where you get your R-rated movies, where while we can restrict their distribution as speech, it cannot be fully restricted, which is why they have the ID checking when you want to watch an R-rated movie. Additionally, definition of no patently offensive means so offensive on its face as to affront current common standards of decency. I pull up for my reference, we have a anatomy drawing, because often artists are drawing anatomy before they're drawing farther things that has a clear artistic value, and then it's also not patently offensive to the average person looking at anatomy. And then we have a classical art piece, which, while it may have nudity, is not in the prudent interests of sex and is not patently offensive in addition to artistic value. In other words, this is affecting one very specific genre of content when discussing anime, and only when that is featuring children, in addition to not having any artistic, literary, political, or scientific value. And I've noticed some people criticizing who gets to decide what constitutes literary and artistic value. This is a criminal charge that they have set up, so the juries are the initial final arbitrators, but before that, the prosecutors, who they're elected and well-educated people, have to assess if there's actually material that you can charge someone for, and after that, if there's any First Amendment issues, as discussed before, that can be ruled on by appealing judges. This is a very controlled system. The judicial system is actually very effective in this particular regard, even if it is slow. Which brings me to people's criticisms of the bill. So this is the introduction to it I saw, where it became clear that I was starting to pick up steam outside of very obscure groups, and I went onto this video and I started pulling comments so I could retort specific points. First off, this is a very common one I see. Drawings are not real, they're fictional pictures. So the issue with that is this particular variety of picture feeds into people who are already addicts and will contribute directly to harm happening. But further than that, it's a moral argument and unrelated to the disinformation. I just wanted to draw attention to it. Next, something I see often is people talking about the obscene issues. Once again, we went over the law that defined obscene. Obscene is very specific, and people who accuse the law of being vague did not take the time to check the law for its very specific definitions. Another issue I have noticed is people being critical of how the art style can make older characters look younger, because anime will typically not portray wrinkles or many other common aging matters because it is often a simplified art style. It's very stylistic in nature. So for example, we have this fellow right here who describes his wife, who was 25, looking young, in addition to other matters of interpretation. So this is different from the obscene definition issue. This is specifically covering what constitutes a depiction that appears to be of a child younger than 18 years of age engaging in the activities. My counterpoint to that is your juries and prosecutors. Remember, if this is gonna become an issue of debate, first off, a prosecutor has to decide this does need to go to trial, because prosecutors drop like 9% of cases they're offered. They only take stuff where they know they will win, more or less. If something can go to trial, and I can argue to the jury, because the prosecutors are assessing based on what they can argue to a jury, that this does not actually depict a individual younger than 18, because the art style and because short women do exist, and because judging ages gets difficult when you're in that general zone of 18 to 25, that charge is going to be dropped. That's not going to be brought against you. The only way that charge gets brought to someone is if the depiction is particularly toward the pre-puberty or very early puberty, where there can be no debate when we're discussing it. Because once you can introduce that reasonable doubt, most prosecutors just drop it. I will also note that because this is relatively common consumption material against people who consume properly illegal content, in addition to people who commit unspeakable acts, this does allow a plea bargaining zone against those people. Also, prior to this point, we do not have an AI law in Texas for this matter. Often you can do that on a federal level, and AI work counts as part of the not allowed on a federal level, but we should not be relying on the federal level to cover law enforcement. That does need to be covered on Texas law level as well. This is another matter I've seen, people warning of slippery slope, give an inch, take a mile. Very libertarian people. I respect libertarians, but our issue here is, once again, this is not speech. This is indecent content with no literary and no artistic value that is being judged by a jury of your peers. This will not get shot down on a Supreme Court level because the obscene definition is specifically modeled after an old Supreme Court case. This is one where they are pulling equivalents out. One says cuties is okay, anime is not. Wow. This is in reference to the Netflix documentary that had a lot of controversy way back. Under this specific set of laws, I believe cuties is not okay. I have not seen it. As I understand it, it does include obscene material that would be in violation of this, and it will likely be taken from Netflix in the state. Except, it does have artistic value. You may not like it, I don't like it, but there is a artistic vision and intent behind it that you can find interviews of the directors going on and on about. Once again, I draw you to the South Park comparison. South Park has has the artistic and the literary value backed behind when they have things that would otherwise be obscene. The following person says Stephen King novels should count under this. Stephen King novels don't have pictures. And another person says a lot of popular anime would be at risk, including Dragon Ball, One Piece, Fairy Tail, Sailor Moon. I've only watched one of these, but it is my impression that none of them contain the intimate scenes that would be described as obscene by Texas law. Conclusionally, I just wanted to kick the channel back, and this was a particular issue that I was noticing. I wanted to try and explain it in a calm, rational manner, because people get very emotional, and things that look like censorship, even if they aren't, have a immediate kind of visceral reaction. Additionally, I chose the slideshow format because I want to start reinvigorating my YouTube channel, and I didn't want to do AI art this time. I plan to talk about it in more detail if I do continue to produce these, but the AI content is starting to make me feel uncomfortable, so I don't want to partake in it. Thank you for your time. Have a good one.